Welcome to Health Law Simplified. I'm Elizabeth, and today we're going to dive into one of the biggest developments in Medicare star ratings litigation in years. So back in May, we covered the Clover decision and discussed why it could have implications far beyond a single plan's star ratings. Well, it didn't take long for those predictions to materialize. A number of MA organizations have now filed lawsuits that either directly rely on the Clover court's decision or were prompted by how CMS handled the aftermath of that decision, which with some recalculations it elected to do voluntarily. So Sandy, our former litigator extraordinaire, is here to walk us through what happened, talk about why these cases matter, what they could mean for star ratings going forward. So, hey, Sandy.
Hi, Elizabeth. It's nice to be here with you.
Yeah, it's great to be here with you as well. So, could we start with a quick refresher on these cases? What happened in the Clover case, and why has it generated so much attention and fallout?
Yeah, happy to. So the Clover decision, we knew it was going to be a big deal, and that is being confirmed. It's become one of the most impactful star ratings cases we've seen because it wasn't just a dispute over how CMS applied a particular methodology. But instead, it called into question whether CMS has the legal authority to use a whole host of measures that it uses to calculate star ratings in the first place. So, just as a reminder, in May of this year, Judge Wood of the Southern District of Georgia ruled that CMS improperly included 20 measures when calculating Clover's star rating for 2026. And Judge Wood ordered CMS to recalculate Clover's rating. And according to reports that were filed by Clover after the fact, that recalculation increased Clover's primary PPO contract from 3.5 stars to 4.5 stars. And that's a huge jump. It's actually more than what Clover was asking for. Clover, in its lawsuit, was asking for an increase to 4 stars. And there are significant positive financial consequences associated with crossing that 4 star threshold. So that's a significant monetary gain to Clover as a result of the recalculation. And we've talked about this at length in our other episodes, but the court's decision really rested on two separate holdings. So first, the court found that CMS relied on data sources that are not allowed under the Medicare statute, and that impacted 10 of the challenged measures. And then the court separately ruled that another 10 measures were also invalid because the CMS didn't comply with notice and comment rulemaking requirements that are part of the Administrative Procedures Act. And just to emphasize why this is so significant, these legal theories are based on statutory authority and like core fundamental administrative law principles, not mere disagreements over calculations, rounding, methodology, right? These go to the heart of the star ratings program.
On that point, before we move on, I'm a political
Mhm.
junkie and I really try to keep my personal views out of this, but I was a poli-sci major. I can't get enough of this stuff. I just find it fascinating to watch during a Republican administration and thinking about the court appointments over this in the last administration that led to things like the Loper Bright ruling, the overturn of Chevron, the restriction on executive agency power, now coming back to haunt this administration and just turn their lives into a really difficult I was going to say a living hell, but they're in a tough spot with this. And it's, these cases are being filed in the Southern District of Georgia because that, this judge is very sympathetic to this idea of, limited federal agency power. And it's all just, we're going to get into the practical stuff because that's what this podcast is about. But it is a really interesting time to be alive and also a health lawyer in this space.
It is truly fascinating, to see CMS reaching so far and trying to do so much during this particular administration,
Yeah.
and then the struggle between the branches of government. That's been an ongoing theme of both of the Trump presidencies, and it has. I think there's no impact, or there's no aspect of American life and government that it hasn't impacted, including Medicare Advantage policy.
Yeah. Yeah. It's like the whole, I'll just give you one more minute and then we'll move on. But our whole system is predicated on the assumption that Congress is going to really do its job of setting policy, making laws, fixing problems in laws they've made before. And because of the void left by Congress not being able to really do that very well, the courts and the executive agencies have stepped in, and then when they're limited, it just kind of leaves a void. But I really won't talk anymore about that because we need to talk about the theories in these cases that are being litigated because they have so much impact on plans. So please proceed.
Absolutely. And I may come back to some of your points at the very end, because I do think the role of Congress is going to be very important in what happens next to the star ratings program. So I referenced, how the legal theories in the Clover case are quite different from what we've seen in previous star ratings litigation. And star ratings has been a hot topic. There have been a number of lawsuits filed by MA plans against CMS in recent years. But historically, that litigation has focused on things like call center metrics, weighting decisions, cut points, statistical methodologies. And these are cases where plans came in and said, we take issue with how CMS has chosen to apply its own regulations. And the Clover case is really different. It challenges whether CMS had any legal basis to do what it did at all. And that's why so many plans and commentators immediately saw the case as having a broader application to other contracts and even to other measures beyond the 20 that were tossed out by Judge Wood in Clover. And we're starting to see that.
So, do you see these rulings as challenges to Clover itself, or how would you characterize them?
Yeah, so there's been 3 follow-on cases to date that have been been filed in the wake of Clover. One by Elevance, one by Scan, and one by Alignment. And these aren't challenges to the Clover ruling. Essentially, the plans have said, we agree with the Clover ruling. We love the Clover ruling. We just want CMS to do for us what it did for Clover. So they're saying CMS recalculated Clover's star rating to Clover's great benefit, throwing out those 20 measures that were invalidated by Judge Wood. And Elevance, Scan, and Alignment are saying you need to do the same thing for us, because if those measures were legally defective for Clover, they are equally defective for every single Medicare Advantage organization.
Interesting. So tell us more. Can you tell us more about the Elevance case in particular?
Yeah, so I think this was the first suit. It was filed on July 1st this year in the same federal district court in Georgia. A really smart decision, right? Because Elevance is a competitor of Clover in that district, in that part of the country. And the argument is really straightforward. If CMS recalculated Clover's ratings, removed these 20 measures that the court found unlawful, why should Clover receive that benefit while other plans are treated differently? And really, it's saying this is a violation of the Administrative Procedures Act to treat similarly situated plans differently, right? There's no basis in law for Clover to get one methodology and Elevance and every other plan to get a different methodology for their star ratings calculations. And this unequal treatment is arbitrary and capricious in violation of the APA. So in the Elevance case, I think it is seeking recalculation that it contends would translate to 115 million additional dollars in quality bonus payments. So that's what the Elevance case is seeking.
And it's just focused on that 1 year calculation.
Correct.
And not
2026. Yeah. And just those 20 measures.
It's interesting because we've talked to folks about this, and one thing that stands out to me is that ruling, if it's upheld, doesn't just apply to 1 year, because the contested measures have been in use for many years. And we've looked back, the federal statute of limitations for federal contracts is 6 years, right? So it's
Correct.
interesting how how selective these organizations are being. I'm not saying I think it's the wrong choice. I think it makes sense under the circumstances to start small and within the bounds of that other case, but this could go a lot farther.
It's really strategic that they filed such a narrow request, that they had such a narrow request for relief. We talked about in our earlier episodes how existential the Clover ruling is, if truly, applied to, given its full effect, right?
Mm-hmm.
If in fact CMS needs to follow notice and comment procedures for every aspect of its star ratings calculations, then that potentially undermines, every single measure that is part of the star ratings. And I think we anticipated that if you made the observation, I recall, Elizabeth, that if a court really understood that it might, mm-hmm. that ruling on notice and comment might not withstand scrutiny on appeal. And mm-hmm. so these plans and their lawyers have not asked the courts to go that far. They're not asking the courts to, completely
tear down this wall.
Exactly.
Yeah.
They're not trying to incapacitate CMS. They're not trying to overhaul the star ratings program, right? I think plans like the star ratings program as long as they're they're doing well. And so it's very strategic litigation. But to your point, there are other years at play here besides 2026, and I expect that we will see broader litigation than what we've seen so far.
Well, before we move on to the other cases that have been filed by Scan and Alignment, is there anything else you think we need to know about the Elevance suit?
Absolutely. One interesting point is that Elevance did seek relief from CMS before it filed this lawsuit. According to the complaint, Elevance submitted a written request asking CMS to adjust its star ratings in the same manner that CMS adjusted Clover's ratings, and CMS rejected that request in writing. And that's what precipitated the lawsuit. And in the complaint, Elevance also takes issue with the industry-wide relief that CMS voluntarily granted to other plans after the Clover ruling. We talked about this on an earlier episode. CMS did do a broad recalculation for all plans after the Clover ruling, but it didn't do what it did for Clover. And Elevance characterizes that effort as a half measure. And it's really we were scratching our heads like, what did CMS do in this voluntary recalculation? Like, we don't
Mm-hmm.
know. The public does not know the methodology. But according to the complaint, what CMS did is it created an entirely new calculation methodology. Some of the measures implicated by Clover were removed, others were retained, other additional measures that Clover never challenged were removed. And Elevance, they contend that CMS really never explained what it was doing or why it was doing it. But ultimately, at the end of the day, the recalculation that CMS did for plans did not provide the same relief that Clover received.
Yeah, that's so interesting. They did engage in some creativity and kind of problem solving on their end. Not completely transparent to your point, and also, yeah, not really authorized by anything, which is a little ironic if you're getting in trouble for doing things that didn't go through notice and comment, and then you just come up with sort of you like MacGyver a fix.
Here's a memo, and 10% of plans are going to get more money, and the rest of you are not.
Okay. So we'll see how that one pans out. But I know their jobs are really hard. I'm
Yes.
making light of it, but they're in a tough spot. They're doing the best they can. Um, and I'm sure acting with good intent. But yeah, it will be interesting to see how that plays out. Well, you want to talk about scan and alignment?
Yeah, absolutely. So we can talk about these together. The cases are very similar to each other. They were filed by the same law firm, the complaints, and they make similar arguments. So scan and alignment, they don't focus on the unfairness issue the way that Elevance does. What they focus on is that second major holding from the Clover ruling, which is the notice and comment rulemaking requirement. So remember that the Clover court found that 10 measures were procedurally defective because CMS had not properly adopted them through notice and comment rulemaking. And SCAN argues that this is the portion of the Clover ruling that CMS has failed to implement. So both SCAN and alignment are saying, hey, CMS, you used these 10 measures that were thrown up by the Clover court when you recalculated our ratings for 2026. And that's not valid. These measures are non-compliant with notice and comment, and so you can't include them. And they've said that if they've asked for CMS to be ordered to recalculate, and if those 10 measures were removed, SCAN believes that their rating would go from 4 stars to 4.5 stars. And I believe alignment contends the same.
That's interesting. And do you know where these cases were filed? Were they in different districts or?
Yes, these cases were filed in the DC, in the
Okay.
District of
Okay.
Columbia.
Okay. Interesting. All right. So just to kind of bring us back down to nuts and bolts, what kind of measures are we talking about that are at issue in these lawsuits
Yeah.
as far as the star ratings measures?
These are important measures, right? They relate to the annual flu vaccination, physical and mental health assessments, risk of falls, access to care, customer service, healthcare quality, care coordination. These are measures that are, plans focus on and are very relevant to the star ratings framework, to, the overall question of what is quality. I contend these are measures that we would want CMS to be looking at. So if courts do begin invalidating them, the implications could impact all plans.
That brings me back to our conversations we had with our experts on the last two, Melissa and Anna,
Mm-hmm.
talking about if you took all of those out, you really couldn't calculate star ratings. If you took everything out, that would be invalidated
Yes.
as a
Yeah,
practical matter.
it's not just those 10 measures. It's all measures. And just to be very clear, because we talk about notice and comment rulemaking, and those non-legal folks, or folks who are not as deep in administrative law, might think that means that there needs to be a regulation. And the reality is that CMS did adopt most of these measures through notice and comment, right? CMS has issued Federal Register final rules saying, we are going to be looking at these measures and we're going to be including them in the star ratings. What CMS did not do is put its technical specifications through notice and comment. So there's a whole technical notes manual that explains how CMS is calculating or how it's measuring plans performance on these measures. And it's that technical detail that Judge Wood said needed to go through the notice and comment process, and that's what plans are asking to be upheld.
And Sandy, under that ruling, would it have been enough if they'd done, because for some things, like I'm thinking about like reporting requirements or big changes to manual chapters, a lot of times they'll just informally issue something in draft and give a comment period, but it doesn't get published in the Federal Register. Do you think that kind of notice and comment would have been adequate under the opinion?
That's a good question. I don't know that. I'd want to look at the case law on that, because I know that APA litigation can be quite technical. That said, nobody is saying that CMS should put this 200-page manual in a regulation in the CFR, right? They're saying it needed to be published to your point, in draft form. That may be enough, and the industry needs to have the opportunity to know what is proposed and ask questions, provide feedback. So I do suspect that sort of informal notice and comment would be, CMS would be in a very different position now if it had gone through that process.
Another thing, again, this is something that ideally Congress would address in a statute and not just, you wouldn't just have to wait for judges to think through it. But if I were a judge looking at one of these cases, one thing I would be thinking about is that these aren't just regulated industries. Like Loper Bright was about fishermen out fishing with inspectors to regulate how they fished and where they fished. These are health insurance companies with government contracts to administer the Medicare program with federal dollars. And so to expect the same kind of notice and comment in that sort of very complicated government contracting context is a little harder for the agency to comply with. You know what I'm saying? Like, as opposed to just a straight up regulation of a truly private industry that's working with private dollars and selling to private people, selling fish.
Yeah, I don't disagree.
Yeah. Well, let's talk about the broader impact. Are there any other cases we should know about that are touching on these issues?
One to keep an eye on, there is another lawsuit. It was filed prior to the Clover ruling by Care First, another Medicare Advantage plan, and it involved the calculation of the 2026 star ratings. It was not predicated on the arguments in Clover, but Clover has impacted the trajectory of that case. The proceedings were paused for the parties to assess how Clover would impact the litigation, whether it would potentially moot the litigation because some of the measures that were at issue in that case are now invalid. So if there is any to the extent any plans have been considering filing, star ratings litigation, this certainly impacts strategy, right? It makes sense to go back and look at how does this ruling change the strategy that we were already considering.
Interesting. And that one's in the DC circuit as well. It's
Correct.
thinking based on it. So that's going to be interesting. We will hear eventually from another circuit as the Clover goes up to the 11th Circuit. It sounds like these
Correct.
cases will percolate up to the DC Circuit Court of Appeals as well.
I just wanted to flag that CMS did file its notice of appeal in the Clover ruling. No surprises there. So that's, I think that's something that is going to impact all of these cases and that we'll be keeping an eye on.
So certainly exciting times for legal analysts and people who follow all of this. But for our listeners that are, as all this proceeds, trying to operate Medicare Advantage organizations, what do you think are the main takeaways for them?
I think what this does is it gives, as we've said before, Clover provides a roadmap for plans that are challenging the application of CMS's star ratings methodology. Instead of arguing that CMS applied methodology incorrectly, plans now have a basis from which to argue that CMS lacked authority to use a measure, or that CMS failed to comply with rulemaking requirements when adopting it. And we also, have to remember we're in a post-Chevron Loper-Bright world where courts are much less likely to give deference to CMS interpretations. So I think there is a much greater incentive now for plans, which, we've talked about how a lot of MA plans are in a challenging financial situation. There is now more at stake and more incentive for plans to challenge CMS's calculations of its star ratings and quality bonus payments. The other potential impact of this is there is now pressure on CMS to overhaul the star rating system, right? There's been a lot of critique of, payments to plans, of the size of quality bonus payments, about how plans are using those dollars. There's been allegations that plans are investing those dollars in supplemental benefits, which then are not necessarily provided to members in the way that they expect. So there is a lot of outside pressure on CMS to reform this star ratings program. I've seen quite a bit of press about how that is a possibility, given the impact of the Clover ruling and all of these other lawsuits. But what I want to remind folks in the industry is that the Clover ruling is predicated on statute, on the Social Security Act and the Medicare Modernization Act. And CMS doesn't have authority to just completely restructure the program unless the statute gives it authority to do so. So it is most likely going to require some kind of input from Congress if there is going to be any major changes made to this program.
Interesting. Do you think this current wave of litigation is just the beginning?
Absolutely. If I'm a plan, I am talking to my actuaries about, how the Clover ruling impacts our company's bottom line and what type of challenge, what measures, need to be challenged in order to have an impact on quality bonus payments. I think that especially if other courts, in the District of Columbia, another court in the Southern District of Georgia, if they continue to accept these theories, I think plans are going to be, increasingly scrutinized whether their own star ratings measures that most impacted their payments were properly authorized by Congress and properly implemented through rulemaking.
Yeah. And if I was working, of course, actuaries, it's not like they're sitting around pulling, this is a lot of extra work for people to do to even have the data that they need to have these conversations. But if I was talking to actuaries, I would want to know 5, 6 years back what would be the implications of different star rating scenarios depending on where things land, um, because these measures have been in place for years. So if they were problematic in 2026, then they were problematic in 2021. Um, so yeah, it's huge. It's
Absolutely.
um, it's been fascinating to watch this, what began as a single MA organization challenge evolve into broader litigation with potentially, industry-wide hundreds of millions of dollars, if not more, at stake. Sandy, really appreciate you wading through these filings and the Clover opinion and talking us through the implications of these developments.
Thank you, Elizabeth. I know we're both very interested to see how courts respond to these arguments, and whether those holdings from Clover are replicated, and potentially a much broader reassessment of the star ratings program is in our future.
Well, we will certainly continue to track these developments. Thank you so much to all of you for listening to Health Law Simplified. If you enjoy this episode, please be sure to subscribe and share it with your colleagues. And join us next time for more insights into the legal and regulatory issues shaping healthcare today. Thanks, Sandy.
Thank you.